My name is Attorney Jillian Leigh Balancio from Estelle and Kennedy. Before I get started on my presentation, I just want to tell you guys a little bit about myself and about our firm. I have been at Estelle and Kennedy for about a year and a half, but I've been practicing for 6 years. I mainly practice in civil litigation, family law, criminal defense, and I do a lot of the landlord-tenant issues at the firm. Our full-service law firm, so we cover all areas of law except bankruptcy and I believe workers' comp. We don't cover that. But again, today is on landlord and tenant issues. So we'll get started. With the landlord and tenant issues, I'm going to be mainly focusing on residential, but landlord and tenant issues also cover the business areas. You know, when you see those like big buildings and you rent out a store to have your store, you rent out space for a law office, that's also considered under a landlord and tenant issue. That's commercial. But today's presentation will be mainly on residential. An overview of the presentation is we'll be going over the eviction process, just from start to finish, what to expect. I'll also go over some of the tenant's rights. I'll also be going over landlord rights, and then mobile home residency law. Mobile home residency law has its own protections because it is involving mobile homes. So I just wanted to share that because not even, some judges don't even know, are not really all too familiar with mobile home residency law. So does anybody here live in a mobile home park or know anybody? All right, well, if you do, you can share the information with them. Like they have their own protections and rights too as residents in the mobile home parks, such as hospitals. All right, we'll give you like a scenario. This is like a typical scenario to segue into landlord-tenant issues. Meet Tina Tenant. She's renting an apartment from Larry the landlord. She's not paid her rent. However, there's a leak in the wall. The tenants above her are extremely noisy. She can't sleep because they are noisy, but she has to wake up early in the morning for work. Rent is due on the 1st. She decides she's not going to pay rent. Larry, landlord, obviously is not happy and wants to evict. So again, we're going to go over the eviction process, unlawful detainer. And for those who are just joining, we are going to go over the eviction process. We're going to also go over landlord and tenant rights individually, and then we'll also go over mobile home residency law if you're just joining us. All right, so this is in general the eviction process. Unlawful detainer cases, or evictions, it's also what it's called, are called summary proceedings. They're very fast. They're not like your civil litigation cases that take a year and a half, 2 years, drag on. It's very fast and it's very black and white, especially if it's just for failure to pay rent. It's either did you pay rent or did you not pay rent. So that's why it gets done within like 30 days. So this is the steps of the process. You have to give notice, landlord gives notice. There's the summons and complaint that are served on the tenant. The tenant files responsive pleading, and we'll go more of this in detail. There's a trial, possibly settlement. We'll go over that as well, and then the actual eviction where you ask them to move out. Like there's the lockout and to get the time to vacate the premises. So notice, in order to start the eviction process, you have to give notice, and notice has to be done a certain way. We'll get into that. But this is the different types of notices you can have, and we'll go over it. There's a 3-day notice to pay rent or quit. I'm sure we're all familiar with that. There's a 3-day notice to perform covenants or quit, and that's pretty much the 3-day notice to correct any violations. And then there's also the 30, 60-day notices to quit. First, we're going to do the 30-day notice to perform covenant or quit, and this notice is given if the tenant is just violating a term in the lease or rental agreement. So a common scenario is if you're not supposed to have a dog, but you still have your pet and they catch you. They can give you that notice and say you have 3 days to get rid of your poor puppy or you need to move out. So usually it gives you time to rectify the situation. Okay?
Is it 3 days or 30 days?
3. Oh, 30. Sorry. I'm thinking of something else. 30 days. It is 30 days notice if you just to fix your violation. And the notice has to be in writing. State the full name of the tenants. It has to have the address of the real property. State the violation. And then state the tenant has 3 days to fix the violation and move out.
What if you don't have a written agreement?
With the landlord. I guess we can go over more of that because I would have to get more facts. I can take, if you don't mind, I can, or would that be better for you guys if we did questions as we go along, or would you rather, I'm pretty open, this is for you guys. Would you like questions as we go along, or do you want to just do the questions at the end?
At the end, so you can do it.
Okay, we'll just do it at the end, and then if you have any specific questions or specific situations, I'd be happy to answer that after the presentation as well. So, the next one is the 30-day notice to quit, and that's in order for a landlord to terminate a month-to-month tenancy. The landlord has to give the tenant 30 days notice, 30 days to vacate. The notice doesn't have to state a reason unless you live in a housing with like tax credits or there's like Section 8 housing. And it's not required if the landlord does not want to renew the tenant's lease. The tenant is entitled to just stay until the end of the lease term. So they just give that. That's a 30-day notice. The next one we're going to briefly go over is the 60-day and then the 3-day notice. The 60-day notice is just when the tenant has been renting for over a year and the landlord wants the tenant to move out, and it's the same requirements as the 30-day notice. So it has to have the name of the tenants, the address of the property, state the reason, and the time to vacate. Okay, so to continue, we're going to do the 3-day notice to quit. And this is the general 3-day notice to quit, which is for tenants who have an ongoing problem and are a nuisance to other people, usually when you commit illegal crimes on the property. So that's when they give that. And it has to be in writing, identify the tenants, state the address, the details, and the incidents of the nuisance, and state the tenant has 3 days to move out. So this is the big one. This is what we mostly see in court. We have the 3-day notice to pay rent or quit. And that's why it's pretty black and white. It's either did you pay your rent by the 3rd day, or did you not? So this is what the tenants will receive if they fail to pay their rent on time. The notice must contain pay the rent or move in 3 days, the amount the tenant must pay to avoid eviction. It can be less but not more. And it has to include the date when the funds are due. And then the landlord must properly deliver this notice to the tenant. The landlord must then wait until the notice period expires before filing an eviction lawsuit. So unless there's a fixed term lease that has already expired. And then there's 3 ways to serve your notice. You could do personal service. You can have one of your agents if you have a property management company, or you have a friend. Just have another person over the age of 18 come personally serve the notice on the tenant. Another way is substituted service. That's if you can't find them, or you think that they're evading, but they have somebody else who lives in the property. After you made at least 2 to 3 tries to get the actual tenant, you can subserve somebody in the house, and then you can mail a copy as well. And then there's also the posting and mailing, and that's after, if there's nobody that you can subserve after your several attempts, then you can just paste it on the board. That's sufficient. And tenants like to argue that, oh, well, I didn't get served, I didn't do that. At most, that just buys them time, but at the end of the day, it always just goes back to, did you pay the rent or not? So, so that's, it doesn't really benefit a tenant if they try to argue that I wasn't served properly. And especially if you show up in court and argue to the court that you didn't show up, the judge tends to say, well, you still showed up, so we'll move on. So, we have the notice, so what now? If the tenant pays before the lease expires, the tenant is safe. No eviction proceedings will begin. And then if they don't, then we'll go on to the next step. And if they try to pay after the 3 days, so let's just say on the 4th day, I'm like, okay, I came up with the money, here you go, I can pay my rent. The landlord doesn't have to take it. And also, just because you don't, it doesn't mean you have to vacate on the 4th day. I mean, you're going to stay, they still need time to file the lawsuit paper, the eviction papers. So you still have time. I mean, it's nothing like to be like, oh my goodness, start panicking. But I mean, it is inevitable and you will probably be served with a complaint, summons and complaint. Which leads to our next slide about the summons and complaint. The landlord is going to prepare a summons and complaint to serve on the tenant. A complaint initiates the unlawful detainer action. It'll state what they're being sued for, asking for how much money, for back rent. If there's an attorney's fees provision in the lease agreement, they might check off that box as well, asking for attorney's action, and then it'll also have the summons, and that's informing the tenant that you are being summoned to court, that there's a lawsuit being initiated against you. So there's a summons and complaint. And then once you're served, you have 5 days to respond. And then there's usually a court form, and I'll provide those list of court forms for you to have as a resource. So don't sit on your hands and wait once you get served. I know it's probably like, oh my gosh, what do I do? You know, get all nervous. But you only have 5 days, so you have to act fast. And then as soon as, and sometimes landlords or their attorneys, they're waiting for that 5 days to expire. So the moment that you don't file your answer, they're ready to default, so they can get that default judgment and get you out. So you have 5 days, and there's different types of responsive pleadings. You can do an answer, and that's a judicial counsel court form, and I'll put the number in an upcoming slide, which form that is. You can just find that on the internet. I like to Google California court forms, and then find the unlawful detainer forms under the subject, and then I'll give you the court form numbers, so if you need that. And that's the answer. And then you can do a demur. These really don't happen all too often, but a demur is another strategy. It's where you argue that they failed to state a claim upon which their claim should be granted. So they're saying like, oh, they want to evict me, but there's not enough facts to support why I should be kicked out. That doesn't really happen in a failure to pay rent. That might happen in a, we'll get into it for mobile home residency law, for example. They can only terminate your residence at a mobile home park for certain reasons. Only like 9 reasons that they can terminate you. So if you don't agree with why they're evicting you, or they didn't state a fact why they should evict you, then you can file what's called a demur. It's a motion. And then there's also the motion to quash service of process. And it's improper service of summons and complaint. But then that also goes back to what I was saying earlier. You can go to the court and argue it, but then there's times where the judge will say, all right, so you're saying you weren't served properly, but you're here. So I think we should still proceed. That could happen. So that's the third tenant, file the response. And then you do have to pay a filing fee. And that's for the landlord to initiate the lawsuit. And then the tenant has to file a response, and there's a filing fee for that. But if you don't have, if you have a low income, you can file what's called a fee waiver with the court, and you can show them that you don't have the funds to pay for a response to the lawsuit or to file.
How much of a fee waiver cost?
You know what? It really depends on the county. Like some courts are like $400, like some people $435, $465. It just depends what county you're filing. So you can check on the court's website on that. So after you file your tenant files a response, the landlord will get served with that response. You just put it in the mail, send it to your landlord or whoever's name is on the caption on the complaint. And then the landlord will then file a request to set the case for trial. And then in 20 days, the court will set out a hearing for your unlawful detainer case. Tenant has the option to have a jury trial or a bench trial. A jury trial is at least $150, I believe, per day. It's for the juror's time. So you can have that, but typically they're just bench trial. And that's where the judge just hears each side and then makes his or her decision. And then during trial, the landlord or his or her attorney will present their case first. They'll have an opening statement, just say they didn't pay the rent or yada yada. They're going to put forth their case. Then the tenant will have a chance to present their case, and they can bring any evidence claiming, bring any evidence to show why you didn't pay it. And we're going to go more into it later. Like for example, they can come. They're like, okay, well I didn't pay my rent because the landlord didn't fix the broken floor in my apartment, or the water heater blew up, or the plumbing blew up, and my landlord didn't fix it, and I told him, so I decided to withhold rent. You know, you have the right to do that. So that's where you can put forth your defense, or you can argue breach of habitability. We'll go more into that, and you can bring witnesses. Either side can bring witnesses. So if you're trying to evict somebody for nuisance, you might bring in all the neighbors that complain about the tenant to testify before the judge. Yes, they have a meth lab in their house, or they have a meth lab in the apartment, or they're having dog fights in the backyard, and they're doing all this illegal stuff. You can have people testify, and that goes to your case too. Another thing I wanted to share with you guys is about a settlement. So sometimes it doesn't always have to be like TV and movies, like go to jury trial and have a judge put the gavel down and make his orders. You can do it as a settlement, reach a stipulated judgment. And that's where outside of the court, you can even be in the courthouse, like literally outside the court, trying to work something out with the tenant. It's you know what, it's actually a little bit more beneficial for the tenant because it will allow them to get more time to move out. So like I've handled unlawful detainer cases and negotiated stipulated judgments where usually they're supposed to be out in 5 days, but now as a result they can have 60 days. Usually when you get sued on unlawful detainer, it's going to go on your credit. And so everybody's going to see that when they run your credit, most landlords do run credit before renting. And I'm going to pause. With a stipulated judgment, you can also do you can tell your landlord or the property manager, the agent who's representing the landlord at the hearing, you can tell them, please, I need to stay, let's just negotiate something. I'm going to put up this defense and you'll likely lose. So how about put me on a payment plan? You guys can negotiate like that. I mean, that's where both parties will walk away. I mean, not entirely happy, but I mean, they're walking away with something versus they're just being, the judge making his decision. You can do something that will be illegal to both parties. So that's called a stipulated judgment. And then if you guys do agree on that, it helps save money on legal fees. You don't have to go through the whole day of trial. It could be a whole half day, a full day, depends how many witnesses you have. And then you can avoid any appeal. Just in case if somebody lost on an unlawful detainer, you have the right to appeal. So if you have that stipulated judgment, you don't have that opportunity to appeal. So that's how it works with trial. Then after the trial, assuming the tenant is unsuccessful, the landlord will get a writ of possession, which the sheriff will serve on the tenant, and the landlord will need to complete the writ of execution form. It's on California court forms, it's going to be EJ-133. EJ stands for Enforcement of Judgment. So you need that form. And then just a fun fact, bankruptcy also puts a stay on evictions. So sometimes when residents' houses are just going in foreclosure in general, they'll also have an unlawful detainer action simultaneously, but then if they file bankruptcy to put a hold on everything, it puts a stay on that. So you can stay in the house.
So how long are they able to stay in the house? How long are they able to stay in the house if they clean bankruptcy?
Until it's all done. Until it's all resolved.
Which is how long?
I don't know how long. I'm not too familiar with bankruptcy law, so I'm not sure.
Is that only if the bank is a bit,
Yeah, I'm just giving that example.
Right,
Like
it's
when
not-
I have
it's not a
foreclosure,
regular-
I have foreclosure clients one time, and then we tried to stay in it.
it's not like a regular?
No, not like a
okay,
landlord.
yeah, okay.
Just something. That's why I said it's a fun fact.
Because it sounds kind of scary if it was.
All right, so here's the forms to prepare the unlawful detainer actions. So if you decide that you want to, you are interested in pursuing your own matter and you want to do it by yourself, these are the forms that you're going to need. It's the summons, it's unlawful detainer. Unlawful detainer, it's sum 130. You got your complaint, ED 100. You have to do a civil case cover sheet, and that's every county has their own cover sheet, and it's just telling the court what is this case for, so they know which courtroom to put it in, which department. The proof of service is summons, and you're going to have your proxy server or your friend, whoever served the tenant, fill that out. You're going to file that with the court. Make sure you file the proof of service. There's so many times I go to court, whether it's civil, family, they don't file that, they have it, but they never filed it. And then the judge is about to kick their hearing out another how many days. Or they forget, and then the judge says, I'm sorry, I can't hear your case today, you need to come back. So make sure you file that with the court. Then once you get your answer, which is the UD 105, you're going to do the UD 150, the landlord will do request to set the case for trial, and then here's your judgment of possession and writ of execution. Alright, so now we're going to go into tenants' rights. I mean, there's so much for tenants' rights, and we don't have enough time. We're just doing the general. So I'm just going to go over the general rights that tenants have in the property. Or in renting either a house or leasing a house or renting an apartment. All right. We have the implied warranty of habitability. In every agreement, there is an implied warranty of habitability. This means that whether it's in the contract or not, the landlord is required to keep the place in a habitable condition at all times. And there's case law, and that's just a general rule from the courts.
What about,
Yes.
what about if it's in your house, they just have their own room, you have to keep the rest of the house habitable, they're not allowed to use the rest of the house?
Are you allowing them to use the house? That just depends on your, I'm sorry, like I don't understand. You're only allowing them to use the
They're
room?
only renting the room, not the rest of the house.
Okay,
They
like
have
they can't
everything
use the
in their room.
kitchen?
No, nothing like that, no.
Um,
It doesn't matter if the house is habitable or not. The room is habitable, it has everything you need, the refrigerator, the microwave, the coffee maker, the blender, it has everything.
okay.
It's self-contained in your house. So does the rest of the house have to be habitable? It's not their domain.
I would say no, because if they don't have any access to it, like that's not part of their living space, but they have their own living space, then I would say no, like if we decided to keep the rest of the property bad,
Mhm.
but their whole space is fine, like you can comply with the code and everything, then yeah, I think that should be good. Yeah, we'll go
Oh, I
ahead.
think I'm sorry.
All right, so then habitable means substantial compliance with local building and health codes. So, and then case law has held that the tenant does not waive his rights under the warranty simply by moving in knowing that the place is substandard. So I remember I had a potential client call in, he said, you know what, me and my fiance, we're a young couple, we moved into this lady's like space that's not even, it wasn't even zoned for a room, it wasn't proper. And he said, there's cockroaches all over the house. Do I still have rights? Yes, because even though like, knowing that the place is substandard, you know, he still has rights to live in a place that is habitable. So then some remedies if your place is not habitable. Some remedies are you can complain, file a complaint with the landlord. You draft a demand letter and just say, bring to the landlord's attention or to the property manager, whoever you're dealing with, bring to their attention the violation. Just say, hey, my water heater is not working, or there's the broken floor outside of my apartment. I can trip and fall. They have a duty to fix that. Or it's too dark in the hallway. I can hurt myself. Can you please put a light bulb? And they don't, you know, then they're obviously breached their duty to you. You can move out. You can call the building inspector if it's just completely sketchy where you live. You can do a repair and deduct. That's where you can fix it, and then you can try to deduct it from your rent. I mean, that kind of opens up the door to litigation there with the landlord, but that's an option you have. And you can also withhold rent, which is don't pay the rent until the landlord fixes the problem. However, this is a risky tactic because the courts are well aware of that, and the courts have ruled differently about withholding rent until the landlord fixes the problem. And then lastly is that you can just file a lawsuit. So, another fun little entertainment for you. Which of the following is, it's a pop quiz, which of the following is the landlord legally obligated to
Before we get to
disclose?
that, I think it would be interesting to know how much time theoretically, or maybe the maximum time or whatever, that the tenant is able to delay the process by going through some of those procedures. How much of a delay can they actually get out of doing that?
About,
In other words, let's say you do a habitability, and you're saying, well, we're filing paperwork to the court that we don't think the place is habitable. How much extra time can, because
and
you hear
they're
these.
trying to evict you at the same time?
No, it's on the other, you're the landlord, let's say.
Okay.
And,
Oh, and then can you tell me that?
the reason I'm asking is we hear these stories that people are able to delay or make the whole process last 6 months or 8 months or 9 months. I don't know if it's just urban legend or if it's true, but how much time?
Well, that depends on, well, I guess that depends on the kind of proceeding. Like if you go forth, like I said, with the eviction proceeding, that's really
Let's say the
fast.
maximum. Let's say the tenant is just out to make a delay as long as possible. How much maximum time could the process be delayed through some of the this action? Because I think people would be curious to know what you would say.
Oh, so like how much time does it actually buy you? Like if I understand the question correctly, how much time does it actually buy you?
Yes,
to
let's say the
complain about
maximum.
this.
Let's say you
Usually those
really-
are, I'm sorry, I don't mean to cut you off. Go ahead.
No, it's okay. Somebody really wanted to harass the landlord and stay as long as possible before they get kicked out, because if it's for possession, they're not going to end up paying
Well,
anything more anyway, so.
That's more just of a defense, so you're going to allege that in your answer. So it's not really going to buy you time unless you file, like I said earlier, you file that demur, you file a motion with the court. It's going to, it's just more of your defense when they say, well, okay, sir, you didn't pay, you got to get out. That's what the judge will say. Remember, I said it's a summary proceeding, black and white. But you can say, oh, no, but they didn't fix this, or they did that. All that does, and the judge could say, okay, well, go fix it. We'll come back in this many days. It's up to the court. But, I mean, they can, but if it's just a matter of fixing it, the judge can say, okay, the tenant can
So
stay,
in
or...
general, because I think what you're saying is the judge is going to be orientated towards, okay, well, if you're claiming the landlord's not fixing it, then let's get it fixed. You still owe the money. Let's go ahead and proceed on this basis of getting it fixed. And owe the money,
Yeah.
right?
Or they can just deduct it, and the judge can say, okay, the tenant can stay, we'll deduct it, pay the rent, can you pay the rent? If you're like, yeah, I can pay it right now, the judge can say pay it or not. So it really just depends on the court proceedings. Yes?
I tried to deduct from my rent for repair, and she says either pay it back or I'll give you a 30-day notice.
Yeah. Well, that's what happened to you personally? Are you in unlawful, are you in proceedings?
No,
right now?
I paid it, but she's not a licensed manager for the property, and it's not hers either. Plus, she's accepting rent under, she doesn't have a registered DBA, and she's cashing checks. Is that not illegal?
I can go over that more with you, because that's a really specific question, and we're just doing a general overview, but I'd be happy to talk with you after, and we can go over all the details, because I need to get a little bit more
That's okay.
information.
That's all right.
All right, so back here to our pop quiz, which of the following is the landlord legally obligated to disclose? Shared utility arrangements, you can't see the B on the screen. B, deaths. C, sex offenders. D, environmental hazards. E, the property is near a former military base.
All of it.
Or F,
All of it.
everybody got it. They're so smart. You don't need me. Yes, all of the above. However, landlords are only legally required to tell you about deaths within the past 3 years, and can only tell you how that person died and that the death occurred. 10.2. So, just in case if you're wondering if your place is haunted. All right. So you didn't pay your rent. So you're the tenant, didn't pay your rent. The landlord cannot turn off your utility service, and the landlord can't change the locks on you. They can't try to handle it themselves. They need to go through the proper steps that we went through in the beginning with the notice. Give them a notice, wait for that time, serve them, wait for that time, and go through the process. You can't just be like, oh, I hate that, turn off the power, turn off whatever, the gas. So, if this does happen, you may sue the landlord to recover actual damages, which is the actual out-of-pocket losses. You can get punitive damages, attorney's fees, a court order to tell the landlord to turn the utilities on. Those are some of the remedies that you can go. Alright, so now we're going to just go briefly into landlord's rights. Just to go over it again, because if you mess up on notice, then you have to start all over again. So just again, as a reminder, the notice has to be in writing, state the full name of all the tenants occupying the home, state exactly how much is owed, have the due date of the rent, and say this rent must be paid in full within 3 days of this notice, or the tenant must move out, and state the day and time the tenant can make the payment. And it must not include other things like the other incidental fees or other interest. It just has to be like how much rent is owed. And again, so be careful when preparing these notices. Otherwise, you have to start all over. Question?
What if you have a tenant and they have moved someone into the house without your knowledge or whatever, so now there's another tenant in the home that you don't know about, or you don't know their full name or whatever?
Right.
Do you have to include them?
You could, say your question again?
Do you have to include them?
Yes, because you're gonna, when you serve your unlawful detainer, it'll be to that tenant and to all occupants in the house, because you're trying to get everybody out.
But I'm saying if you don't have their
even
name,
know.
how do you do that?
And all.
How-
Just
how
put
did
on
you-
an all.
How did you know about that?
No, you put on all to all occupants, you don't have
Yeah.
to name
Yeah.
them.
You don't have to name them.
You put on to all occupants.
It's the does
Okay.
1 through 5.
Right. But then that's another issue to bring up, because if you have that lease agreement with your tenant, usually you say, like, there's always usually a provision saying you must inform the landlord who is living in the house, to give them notice of that. So if they're bringing in people without notifying the tenant, then that's in violation of the agreement. So they're in breach. Another important thing I wanted to talk about with landlords, and it's because it's been an issue in the legal community. It's pretty split about attorney's fees, about having attorney's fees in your lease provision, attorney's fees provision in your lease agreement. Under the law, generally, in order to obtain attorney's fees, a statute like a law or a contract has to allow for attorney's fees. But again, it's split on whether landlords should include it or not, because whether or not it's recoverable. And then also, even if the attorney's fees provision is one-sided, like, so sometimes it can say, if I have to bring an unlawful detainer action, or we need to enforce this agreement, landlord is entitled to attorney's fees. Even though it says that language in the fee agreement, the judge will interpret it. To go both sides. So let's just say you go forth with this unlawful detainer, and you're like, I'm going to ask for attorney's fees because I had to bring this. And then the tenant argues their case, and the judge says, yeah, tenant wins. And then tenant has his or her attorney, and she has her fees. Now you have to pay their attorney. So, and then in the event where you're the landlord and you win, obviously your tenant's not paying rent, so they don't have the money. Will you be able to obtain that attorney's fee from them? So sometimes what landlords do is you can do what's called a fee cap. You can put that in your agreement, and you can say attorney's fees, the max we'll pay is $1,000. The max we'll pay is $750. Take a look at your tenants. Are you like in like Ranchos Palos Verdes? Do you have wealthy clients? Do you have clients that are just, you're not sure if they can pay? So look at the type of clients that you have and see if it is recoverable, if that's worth it for you to have. It really is up to you. It's a gamble, because if you might have to pay them, or if not, then you might not be able to recover anything. So that's just something that's been going on in the community. I mean, here's the pros and cons. Again, it just tends to benefit the tenant, because the tenant, when they can collect against you, but you're going to have the pockets to do that, but they don't. All right, and then we're going to go into mobile home residency law and evictions. Mobile homes residency law has its own protections, separate from like just having a regular like apartment and house, because public policy recognizes that it's really hard to remove the property, like to remove a mobile home, it'll damage the property, damage the space. So there's that unique protection that residents have who live in mobile home parks. And that's under the, governed by the California Civil Code, section 798. And then with that, there's the notice to your tenants. It states the specific language that the notice must have. You must state the reason for termination of the tenancy, and we're going to go over, there's only a few reasons you can terminate tenancy. And it must have specific facts to permit the termination of the day, place, circumstances concerning that reason. And you must serve the residents and the homeowner, and it's a 60-day notice. So here are the authorized reasons for termination. The first one is failure to comply with a local ordinance or state law or regulation relating to mobile homes within a reasonable time after the homeowner receives a notice of non-compliance from the appropriate government agency. So maybe something changed in the rules where they can't have a certain thing, they can't have this or that, and you get notice, and you as a tenant or the resident don't comply with it, then that's grounds for them to provide you 60-day notice to terminate. The next one is conduct by the resident or homeowner upon the park premises that constitutes a substantial annoyance. This is all governed under 798.56 under the Civil Code. Substantial annoyance is really broad, and there's no specific case law that really defines substantial annoyance, but there are cases that indicate what constitutes a substantial annoyance. So, for example, discharging firearms inside a mobile home, physical violence, threats to kill other residents in the park, trying to run somebody else down, drugs, alcohol, selling to minors in the space, manufacturing drugs on the property. Those have constituted substantial annoyance to the courts. And then the next one is conviction of prostitution or being convicted of a felony possession of a controlled substance. If that happens while you're in the park, your tenancy can be terminated. Next is the failure of the homeowner or resident to comply with a reasonable rule or regulation of the park. That's part of the rental agreement. So if there are specific rules, you can't do this, you have to dispose of your trash, or going back to the question back there, what if they start bringing in other people and it's not part of they're not complying with the lease, you can give them that 60-day notice to terminate. And then the next one is letter E. This is just basic non-payment of rent, and it has to be laid at least 5 days. So you have to give them that grace period, and then give them a 3-day written notice. And if they pay within that 3 days, the default's cured. And then if you're a tenant and you're always late and you constantly get 3-day notices from the landlord, then no written 3-day notice is required. They'll just serve you with a 60-day notice and say, you're done. And then, so that's another reason. And then 2 more reasons that they can terminate you terminate your agreement. It's condemnation of the park, and that's when the government decides to just take over the land and they can't have that park anymore, so they have to go. And then next is the change of the use of park, or any portion thereof, and so long as the management tells the tenants that they're going, at least 15 days, that they're going to go before a board and tell them that we're going to change the use of the residential park. So for example, it could be residential now, but they're going to change it to become for business or something. So they're not going to have like residential homes there. So they have to give that notice. And then it's the same requirements if you're a defaulting tenant. So if you don't meet if you don't do what you're supposed to do, it's all this is the same requirements. And that's under 799.70. Non-payment of rent, convictions, failure to comply with ordinances, substantial annoyance. Here we have the failure to comply with the rules of the park, condemnation, change of use, and these are the only ways, again, you can be asked to. So that's pretty much it. If you have any questions, we can call that. Any other issues, or you want to continue this conversation, give our office a call. We offer a free 15-minute consultation over the phone, or you can come in for a paid consultation. So thank you for listening.